Hello, I'm immigration attorney Alma Rosa Nieto. I'd like to talk about a new directive that the President and the executive branch gave early January year 2012. It changes the way the procedure for obtaining waivers for illegal presence in the United States. Before, someone applying for permanent residence, if they have illegal presence, that means they've lived in the United States more than 6 months or 1 year, they accumulated illegal presence, and when they went out to their country, to the American embassy to get their green card, they would be charged with a 3 or 10-year bar. So everyone that went abroad to the American embassy to attempt to get a green card always went not knowing if they could come back and if they would stay 10 years in their country. This new directive from the President is that now a waiver can be requested within the United States. That means that it will be processed and either approved or denied in the U.S. It is not an amnesty, it is not a new law, it hasn't changed the requirements for a waiver. They continue to be the same. Extreme hardship to a United States citizen parent or a lawful permanent resident parent or a spouse who is a resident or a United States citizen. So the requirements are exactly the same. The standards have not been softened. The only thing that has changed is that a person wanting to get a green card can apply for this waiver within the United States and then go to the American embassy. You still have to go abroad, and once you show up to the American embassy, you show the consul your approved waiver. This raises your possibilities of getting your green card approved at the embassy. And before, a person would have to be out in his home country to see if he would get this waiver from 2 months to years. Now, with the waiver in hand approved in the United States, there's less separation of family, and a person goes to their home country to attend the interview with the U.S. consul at the American embassy for maybe a few days or a few weeks. So this is godsend for many people that do not want to separate from their family. Now, who does this apply to? If you are being petitioned by a United States citizen parent and you're a child, or if you're married to a United States citizen. It does not apply if you are being petitioned by a permanent resident. That means someone with a green card. So this does not change the requirements. You still have to show extreme hardship to a parent or spouse, and the fees are the same with immigration. It just changes the location where you can file the waiver. Instead of it filed abroad in your home country with the risk of being denied and having to stay out years, now it'll be applied for and approved or denied within the United States. The final interviews will still be in the home country. Many people think that because of this new directive they don't have to go out of the United States. They still have to go. So this is the information, the latest, and I will be giving a part 2 with more benefits, pros and cons of filing a waiver, when we can start filing a waiver, which apparently, according to USCIS, which is the Immigration Service, will not be for a few months. Until next time, I'm attorney Alma Rosa Nieto.